My name is Thomas Mackey. I'm at the University of Louisville History Department and with the Brandeis School of Law here at the University of Louisville.
I'm Rita McCannon. I'm an attorney in Huntsville, Alabama. Hope you can understand my Southern drawl.
Hi, I'm Jay Barth. I'm the Chief Education Officer for the City of Little Rock and a retired professor from Hendrix College in Arkansas.
How about you guys tell us who you are this morning before you get started? Tom, you may want to prepare them.
Yeah, go ahead. I think that at this point, you guys want to introduce yourselves and maybe your teacher, and then we'll launch in, okay?
I'm Jasmine Kush.
I'm Aiden O'Neill.
Marjorie Black.
I'm Kate Zonin.
And this is our teacher, Mrs. O'Brien.
Okay, those of you who don't have your sound turned up, please do that. And those of you who are on mute, which is fine, when it's your turn to talk, be sure to turn yourselves on, okay?
Jasmine, can you just speak again? I feel like you're coming in and out.
Say your name, Jasmine.
Jasmine Kush.
Okay, need to
Okay.
turn your volume up for us, just a little bit.
Or you might need to leave and come back. I'm not sure. You don't seem to have great reception. No, that's not what you want.
Well, I don't want to lose her.
If you have anything else open on your computer, if you can turn down those other things and just have the Zoom, if that's possible, that might help.
Well, let me go ahead and get started so that we can stay a little bit more on track here, okay? Again, this is Unit 3, and we're going to be doing this morning question number 1. Question 1 reads as follows. I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review? You may begin. Did that work through?
It seems like Jasmine left the meeting and I assume that she's the one who goes first. Is that correct? Okay, so,
Okay.
Hopefully
we'll-
she'll come right back in.
Okay.
Right, and we'll just hold a minute. Let's see if she comes back and I'll do it again. Okay, no problem. Been here, done this. It's okay.
I noticed it's not a problem. I just realized I didn't hear it. Tell us where you're from, one of you.
And we're all freshmen from North Smithfield High School.
At what? I
We're
can't hear.
We're freshmen from North Smithfield High School,
And where is
What
North
state?
Smithfield?
Rhode Island.
Rhode Island. Wonderful.
Oh, here's Jasmine coming back.
She coming back? Okay.
Mhm.
There she is.
Better now? Okay.
A little bit. Yeah, make sure your sound is turned up for us. You a little better?
I think so.
Okay. So let me read the question one more time and then you can get started, okay? All right. Quote, I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review? You may begin.
Judicial review has been around since the 17th century English system of law. Federalists and Anti-Federalists always assumed that the Supreme Court had the power of judicial review. The framers of the Constitution expected the courts to interpret the Constitution actively in order to react to new conditions. In 1943, Justice Frank Murphy wrote in Schneiderman v. United States that, quote, the constitutional fathers, fresh from a revolution, did not forge a political straitjacket for the generations to come, end quote. Not only does judicial review help to limit government, but it also has a huge impact on federalism. Oliver Wendell Holmes was right when he declared that judicial review at the state level is more fundamental than it is at the national level. There are more dangers at the state level solely due to the more one-party domination. Even James Madison argued in Federalist 10 that the greatest threats to liberties would occur in small republic. Although judicial review is now established, it still evokes controversy today.
Marbury v. Madison, Chief Justice Marshall affirmed the power of the Supreme Court by concluding that the Constitution is, quote, the fundamental and paramount law of the nation. Consequently, an act of the legislature repugnant to the Constitution is void, end quote. He mentioned Article 3, Section 2, which extends the judicial power to, quote, all cases arising under this Constitution, end quote. Referencing Article 6, Marshall confirmed that the Constitution is a higher law that the Supreme Court must preserve to protect the people. In Federalist 78, Alexander Hamilton argued that judicial review isn't counter-majoritarian. He maintained judicial review as a means to void all government actions contrary to the Constitution. He believed that limitations on the power of the federal legislative and executive branches in order to protect the rights of individuals, quote, can be preserved and practiced in other ways than through courts of justice, whose duty it must be to declare all acts contrary to the Constitution void.
Hamilton countered arguments that this power can make the courts too powerful by enhancing that judicial review, quote, only supposes that the power of the people is superior to both, and that with the will of the legislator declared in the statute stands in opposition to the people declared in its Constitution, they ought to regulate their decisions by the fundamental laws rather than by those which are not fundamental. This meant that the people ratified the Constitution as a higher law. So therefore, voiding popular law still ensures that the will of the people is paramount. For example, in Loving v. Virginia, the Supreme Court ruled that laws banning interracial marriages violated the Equal Protection Clause and Due Process Clause under the 14th Amendment. Although many states didn't approve of this ruling was in favor of those who supported the ideals in the 14th Amendment.
Although Hamilton argued that the court had no power of the purse or the sword, since the early 19th century, the debate has continued over how federal judges should use their powers. One limitation on their powers is judicial restraint. This is when the courts uphold all acts of Congress and state legislatures unless they clearly violate a specific section of the Constitution. In West Virginia v. Barnett in 1943, Frankfurter mentioned, quote, as a member of this court, I am not justified in writing my opinion into this Constitution, no matter how deeply I may cherish them. It can never be emphasized too much that one's opinion about the wisdom or evil of a law should be excluded altogether when one's doing one's duty on the bench, end quote. Another way to limit the impact of judicial review is by the passage of an amendment. This has occurred 4 times.
However, we believe that the power of judicial review should not be further limited. It has allowed the Supreme Court to become the guardians of the people's liberties that James Madison said it would be at the inception of the Republic. Madison predicted during the First Federal Congress on June 8, 1789, that, quote, independent tribunals of justice federal courts will consider themselves in a peculiar manner the guardians of those constitutional rights and resist every encroachment upon rights expressly stipulated by the Declaration Bill of Rights, end quote. Placing limitations on this power would take away that major protection and would cause needed social change to be left unnoticed. Most of the laws declared unconstitutional since 1925 have involved civil liberties guaranteed by the Bill of Rights and subsequent amendments concerned with the rights of individuals. Clearly, judicial review
Time.
is a vital power
Finish, please.
and plays a major role in keeping our nation whole to this day.
Well, cool, interesting stuff. There's a lot to get a handle on here and a lot to kind of think about in interesting ways. You've focused heavily, and I understand the question drives you towards the 18th century, and yet you've also talked a little bit about judicial review as a defense of minorities and more recent issues. How do you understand judicial review today?
Judicial review is whether or not something is deemed constitutional or unconstitutional. So I feel like a lot of issues today are requiring that, like how recently they decided on whether or not flag burning was constitutional or not.
How did that one come out?
I think they deemed it constitutional but not like recommended.
Okay.
Let me ask you a question about what you think about the appointments of people to the Supreme Court. Senator Ted Cruz had a book called One Vote Away. And in it, he said that a single Supreme Court seat can change history. Do you all think that's true? And tell us why.
I believe it's true because if there's an even number in the court, even though there's not, and even though there's 9, there could a certain judge's opinion could change the way a court case is understood and the way a court case is solved.
I agree, especially if that court case can like change how America works or like how the nation is positively changed.
Can you be specific on what that might look like, Mr. O'Neill? You know, you said how the country works or would be changed. Can you be a little more specific for me?
There could be a case allowing immigrants in, and if that one person, that one court judge, he decides that immigrants can be allowed, then the economy will be changed positively.
It could strongly persuade or influence many things.
So with like an even number on the court, like in US v. Texas, when they ruled 4-4, they had to abide by the Fifth Circuit Court's ruling.
Okay. You made the statement, and Madison, I think in the 18th century was right to say that the states, the real danger to federalism is going to be from the states. And yet, since the 1930s, we've built this administrative state. Power has shifted to Washington, D.C. Is judicial review, or you could speak to federalism if you prefer, but is judicial review still effective against the federal government in the sense of the sheer size and breadth of power that the federal government now wields?
I feel like we are able to, because in US v. Nixon, the justices, they ruled against him, I think, or like they said that like the justices that were appointed by him, they didn't go for his like opinion because they serve for good behavior, so they wouldn't have to go by his views because they were appointed by him. And judicial review, like it put the president, Nixon was the president, and they put him in check.
Hi, so are there any types of cases into which the Supreme Court should not intervene?
They shouldn't intervene in cases that are too political and show partisan towards a certain group or a certain majority or minority group, because the court isn't, even the court may be partisan, it's not supposed, the founders didn't want the court to be partisan.
Yeah, and for a while the court even refused to like rule in any courts regarding redistricting because they saw it as too political. But then that changed in Baker v. Carr when they said it was a judicial question.
Jay, you.
Hit the wrong button. Hi, Olivia, do you think they got it right in Baker v. Carr by opening the door to engaging in redistricting?
I think they did, because it was such a major problem. If they hadn't done anything about it, then there would have been no changes occurred because of that ruling, they were able to rule in Reynolds v. Sims, one person, one vote, which I think helped redistricting. Even though it's still a major problem, I think it's just like a step closer to where it needs to be.
Thank you.
But I think that leads to the question of the counter-majoritarian issue. If majority of people in a state like where the districts are, why should the federal courts, unelected, unaccountable federal judges, tell the people in the states how they should establish their electoral districts?
Well, because even if the people like it may not be supporting the minority, which is also important because of the principle of popular sovereignty. Popular sovereignty says that the government should be supporting who they govern, the people are who they govern. So the district should be able to support everyone, not just the majority people.
And we can see with Madison, he really supported the majority versus the minority, and how we should distribute how much power we give to the majority or the minority.
The court also used this same idea in Loving v. Virginia and Brown v. Board of Education, because even though majority of the people didn't want them to rule to force desegregation in school, they still did because they thought it would be best for the majority of the people.
Can we talk a little bit about whether we should place term limits on the on what are now lifetime appointments for Supreme Court justices? What are the arguments on both sides, and where do you come down?
Well, if we set a term limit on the justices, it can allow more justices to be brought in, and it can bring new ideas and more advancement to the chamber.
On the other hand, if we keep justices in for a lifetime or for good behavior, it can also make them more knowledgeable because they'll have more experience and have more ideas as they go along in their careers.
Going back
agree,
to
I
what
think-
Jasmine said, even though justices are for good behavior, it's still technically life if they follow what the people want. So if they continue to serve for good behavior, which they can mean life, no new justice will be able to share their thoughts.
I think they'll be more used to it, and I think that it's so important to have someone who already knows what to do and what to expect. So I think on good behavior, I think that's so important.
What about the idea of judicial independence? I know Madison and the founders were really concerned about that idea. Does term limits, because they have to serve during good behavior, but would term limits really limit their judicial independence? Or is that so entrenched that we don't have to worry about that issue anymore?
I feel like it would lessen the possibility for judicial independence, because it's allowing more restrictions, so like they can't serve for a longer time. So like the people that would be a part of the judicial branch, like the justices, they would only have a limited time to serve, so they wouldn't be able to get like as much progress.
Time.
All right, there we go. Yeah.
Oh,
Breathe again. It's okay.
I wish your mamas and daddies could be here clapping for you. How great this was.
Yeah. Let me go ahead and say, okay, look, if I heard correctly, while we were still having some issues, this is a group of freshmen. Is that correct?
Wow.
Right? Okay. This is really impressive because there's a lot of material. These ideas are pretty complex, and you did a nice job of managing these big ideas. Now, a couple of things. Always try to bring some examples, some specifics. Remember, I was asking Mr. O'Neill if he could be a little more specific. So make a statement, then back it up with a statute or a case or something more hard to really drive your point home a little better. So I think you did just fine, Mr. O'Neill, don't misunderstand. But you just need to back up a little bit more what you're saying. I also thought you covered the waterfront from the founding period of the 18th century up through the early 21st century. And I thought that was really nice and impressive as well. So let me turn it over to my colleagues now.
There are an awful lot of senior high school teams who don't associate the cases, the number of cases, the various cases that you guys did. I will make one recommendation, and it's partly from experience and partly from what we heard this morning. But be sure, if you're going to talk about a case, that you have at least read a good bit of it. The line that says what the case is about is not enough. If you get asked a specific question about a specific case, and all you have read is the little synopsis at the top, I'm not saying you have to study every single one. You all nailed putting the right case with your answer, and that was very good. But be sure once someone was asked to name a specific thing. Well, if you're going to mention that case, tell why specifically that case had something to do with that question. That would help. Brown versus Board of Education was a great, and you actually went into the answer that it would help the people of the United States. The unfortunate thing to me is that until it was forced on them 12 or 14 years later, they didn't do anything about it. They got the order and they didn't do what they were supposed to do about the schools. So if you know a little more about the cases about which you speak, it will translate in your answers. But I am so impressed. I cry at the Star Spangled Banner, but I'm in tears this morning at how terrific you are and how much you have learned in preparation for this morning.
I think you also got stronger as the process went along. You got more confident, and that was very obvious. I totally agree with Rita that it felt a little shaky on a couple of cases in terms of outcome and exactly what was going on in those cases where they ended up. So have deeper knowledge of some of the cases, or at least show more confidence about them. I did think early on y'all were cruising. Y'all were talking really fast, and Rita and I have very slow ears as Southerners. So Aiden in particular, you were booking at the start. So take a breath before you start speaking and just have a little more. You got plenty of time. You packed a lot in, and it's better to go a little slower and show a little more kind of confidence, because I think if you're going too fast, it feels a little like you've maybe over memorized or over prepared. So show a little more timeliness in that.
Okay, that concludes our time. I'm afraid we have more students waiting to come in, and I'm sure you guys need to go as well. Thank you very, very much for everything. You did a great job.
Great job.
Great job, Unit 3.
Bye.
Thank you.
Bye.
Good luck, Miss O'Brien.
Thank you.